let's take a look at Illinois law here. Now, this is drawn from our Illinois specific course on self-defense law. We have state specific courses for each of the 50 states. This is our Illinois course. You can get the course for your state at lawofselfdefense.com/state. I'll leave that little banner up there on the bottom. And this is from the section of that course on the element of imminence. And I'm only going to use this one because it lists the relevant statute, which is this one, Illinois. I believe it's Consolidated Statutes, ILCS, Section 7-1. This is Illinois' core self-defense, defense of others statute. Here I've bolded imminent because this is from the imminent section of our course on Illinois self-defense law, but we'll see all the elements here except for innocence, and I'll circle back to innocence, and of course except for avoidance because Illinois is a stand your ground state. So what have we got? Now, it's a very common structure we see here. The first sentence of this defense of person statute deals with non-deadly force, the conditions that have to be met before even merely non-deadly force. A shove, defensive use of pepper spray, before even non-deadly force can be used in self-defense. And then the second sentence adds additional requirements before deadly force can be used. So the statute reads, a person is justified in the use of force against another when and to the extent he reasonably believes that such use of force is necessary to defend himself or another. That's people, right? Yourself or another person. Not property, not a pet, people. Against such others' imminent use of unlawful force. So in order to be justified in the use of non-deadly force in self-defense, it doesn't say non-deadly, right? But the second sentence goes on to read, however, he's justified in the use of force which is intended or likely to cause death or great bodily harm only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another. So we see here really the four elements required by Illinois law. One of them a little weakly, innocence, but I'll circle back to that. So clearly we see the reference to imminent, right? You must have been defending yourself against an imminent threat. Proportionality is reflected in the fact that the first sentence deals with non-deadly force and the second sentence deals with deadly force. That's proportionality. And of course, the additional requirement here is you're not justified in using deadly defensive force unless you're facing a deadly force threat. And deadly force includes, of course, force that can kill, cause death, but also force that can cause great bodily harm, maiming, injury, blinding, broken bones, rape, kidnapping, things of that sort. Avoidance is off the table because Illinois is a stand your ground state. And we see reasonableness here reflected in this phrase, when and to the extent he reasonably believes that such conduct is necessary. And in the context of deadly force, only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm. What about innocence? Well, you might say that innocence is kind of baked in the cake here when they refer to using force to stop an unlawful use of force against you, right? If someone's using unlawful force against you, they're the aggressor. But Illinois actually addresses this question of innocence, the element of innocence, more clearly, but in a second statute. So let me get to that second statute here. And what it does is it excludes from the justification of self-defense people who were the aggressor in the confrontation. So this is Illinois Statute 7.7-4. The justification described in the preceding section, meaning the justification of self-defense, is not available to a person who is attempting to committing or escaping after the commission of a forcible felony, or initially provokes the use of force against himself with the intent to use such force as an excuse to inflict bodily harm upon the assailant, or otherwise initially provokes the use of force against himself. So if you're the provoker or you're engaged in the commission of a forcible felony, you fall into the definition of aggressor. excuse me, you lose the element of innocence, you lose the justification of self-defense. So when we consider this event, what are we looking for? Well, we're looking for innocence, imminence, proportionality, and reasonableness. So let's consider proportionality first. Is there force being used here? Yes, these two men are pushing and shoving each other. Does it appear to be mutual? So one of them is not saying here, hey, buddy, I don't want to fight. I don't want to fight, right? They're both engaged in the use of non-deadly force against each other. That's what we term mutual combat. When you're engaged in mutual combat, you're really mutual aggressors, and you've both lost the element of innocence, and you've both lost self-defense. In any case, of course, what they're engaged in is non-deadly force, as near as we can tell, right? It's just this hand clasping, this pushing, this shoving, this wrestling. I mean, it's not friendly, really, but it certainly doesn't appear to be force likely to cause death or great bodily harm. So there's no apparent deadly force threat here. Now, generally speaking, one trick here for the guy with the gun is, even if we pretend that his shooting would otherwise be lawful, a problem he has here is, generally speaking, you're allowed to use deadly force in defense of another person to the same extent they would be privileged to use deadly force in defense of themselves. Would the gentleman not shot here, engaged in the wrestling, would he be privileged to claim self-defense himself to justify what's going on here? I would argue no. I would argue he's a non-deadly force mutual combatant, doesn't have a privilege of self-defense. And if he doesn't have a privilege of defending himself, it's really unclear if some third party would have the privilege of using force on his behalf. So another complication here for the guy with the gun. So that's the issue of proportionality. Even if the guy with the gun would have had a privilege to use force in defense of others here, on the issue of proportionality, why is he using deadly force when there appears to be no deadly force threat, either to himself or the guy, I suppose he was thinking he was defending? So he loses on proportionality. Imminence doesn't really matter. I guess there's some imminence threat going on, but again, mutual aggressor, we've lost innocence. So we've lost innocence. We've lost proportionality. What about reasonableness? Well, reasonableness is really like an umbrella element that sits over the other. So it's actually asking, well, were your perceptions of innocence and imminence and proportionality, were they reasonable perceptions? We're not required to make perfect decisions in self-defense. We're allowed to make mistakes in self-defense and still be legally justified. A classic example might be, you see an object in someone's hand and mistake it for a knife. And so you use deadly force in self-defense against that knife, and it turns out not to be a knife after the fact. So you were not, in fact, facing a deadly force threat. You made a mistake of fact in evaluating the threat. You can still be legally justified in using deadly defensive force if your mistake would have been a reasonable mistake. A hypothetical, reasonable, and prudent person would have made the same error under those circumstances. So the object in the hand could well have been perceived as a knife by some other person. It was not an irrational misperception on your part. So we don't see any of that in this video. I see zero reason for a gun to be coming out here by anybody. But the gun does come out, comes out right there. This dude decides to fire 2 warning shots into the air. Folks, it's very difficult for me to imagine circumstances in which warning shots are a good idea. Especially like here, you're just shooting those rounds up into the air. The rounds have to come down. This is presumably a populated area. There's a pizza joint and a bar, and there's cars driving down the road. This is reckless endangerment, which with a firearm is a felony. Felony, because you're causing an unjustified risk of death or serious bodily injury to other people. Even if your bullet doesn't hurt anybody, you're creating, for no good reason, no justifiable reason, this risk of death or personal injury to innocent bystanders in the community. Would it be different if he fired 2 rounds into the ground at his feet? I mean, maybe, maybe if you're standing on dirt and there's a good prospect the rounds are going to get buried. But firing in the air, for sure, the rounds have to come down, right? They're not going into space. And people get killed by bullets fired into the air with some regularity. So very common, in my experience, to see prosecutors, if they bring no other charge, say he stopped with the warning shots here, you're looking at a reckless felony endangerment charge, which is bad. It's a serious offense. Now, the video ends right about here. So he fires the 2 warning shots. Now he's pointing a gun. He points the gun at, I guess, Perkins, the guy he's intending to shoot in a moment. What's the pointing of this gun? Say it had stopped here, and he never fired the fatal shots, the next 9 shots. He fired the 2 warning shots and just pointed the gun at Perkins. Well, pointing a gun could be justified as self-defense, but we've already concluded that the facts here don't support a self-defense analysis per the elements of self-defense in Illinois law. Several of the required elements are violated. And therefore, there is no self-defense justification here. And if you point a gun at another person without a self-defense justification for the purpose of changing their behavior, even if you don't fire a round, that's aggravated assault with a deadly weapon. You're putting that person, without justification, you're putting that person in imminent fear of death or serious bodily injury. That's aggravated assault with a deadly weapon in many jurisdictions. That's good for 20 years in prison, especially once you add on the firearm sentencing enhancement for having used a gun to do it. That's not great. So I also discourage, I don't tell you not to do it, because I don't tell people what to do. I won't be there when you find yourself confronted by a criminal aggressor. But I discourage defensive display of guns unless the circumstances would warrant actually firing a shot. But merely displaying a gun in an effort to, I don't know, intimidate the other person or, to change their behavior for any reason, I think is a bad idea, because most of the cases I work on are aggravated assault with a deadly weapon cases where a gun comes out, never fired, no one's hurt, but it's pointed, puts the other person in fear of imminent deadly force harm. Prosecutor brings a charge of aggravated assault with a deadly weapon. And typically that defender, the cases I consult on, typically those people have never been in trouble with the law before. And now they're looking at a 20-year felony. And often it's because they did it because they got scared. I mean, they didn't know the 5 elements of self-defense. They didn't understand where the legal boundaries for lawful use or threat of deadly force really were. They got frightened. They had the gun on them. It was the only form of self-defense that they had, even if it wasn't justified under the circumstances. And so they drew the gun. Don't do that, folks. Know when you're privileged to pull a gun out and point it at someone. So even if he hadn't fired the 9 rounds here and killed this guy, just pointing the gun at him could be enough for 20 years in prison. But of course, he doesn't just point the gun. He then goes on to fire 9 more rounds. Now the video ends, so it can't inform us about whether or not the circumstances changed in some way that might justify the firing of the 9 rounds. Is it possible that there could have been circumstances after this video ends that would justify the firing of 9 rounds? Well, sure. The circumstances could be that Perkins, the victim here, suddenly did something to present as an imminent deadly force threat. Did Perkins reach for a gun in his waistband? That could justify this Freund firing, using deadly force to defend himself from an apparent imminent deadly force attack, or a knife, or now if there is, of course, a barrier between Perkins and the shooter. So if Perkins were reaching for a knife, would that be an imminent threat to the shooter? Maybe not, because of the railing that separates them. It would be an imminent deadly threat to the guy he's wrestling with, Perkins is wrestling with. So maybe then it would be deadly force in defense of others. What had been a non-deadly force fight has now been unlawfully escalated, perhaps, to a deadly force fight. If Perkins was preparing to present a gun in a manner that Freund could recognize, then Freund would have reason to fear, perhaps, that the gun would be used against him. Of course, everything that led up to this that was unlawful, apparently unlawful, is going to present problems for Freund, because Freund wasn't just standing there with his hands in his jacket and Perkins reached for a gun. Freund was doing all this other stuff, the warning shots, the pointing of the gun under circumstances where it wasn't lawful, in which case I would argue that if Perkins was reaching for a gun, he was lawfully defending himself against Freund's threat of deadly force, which again would just make this murder. But if we pretend that Freund would have been justified in shooting Perkins at all, now we have another complicating factor, because under what circumstances could he be justified in shooting Perkins 9 times with a 9mm? Now, the law says you can keep shooting someone as long as they continue to present as an imminent, unlawful, deadly force threat. And if that takes 9 rounds, if they keep coming and you have to shoot 9 times, the law says that's permissible. But does it seem likely that 9 rounds were required to stop whatever Perkins was doing that Freund thought would justify shooting at all? 9 rounds is a lot. Now, often people miss a lot, so they're not getting many hits, or they're not getting good hits, effective hits. That's often a reason that high round counts are required. They're pretty close to each other here. And apparently, after the video, they even get closer, that Perkins was advancing towards Freund, according to the news report. Do you miss 9 times under that circumstance? And how do you justify 9 hits? I mean, it can be. The facts could theoretically support that, but it's hard to imagine a circumstance in which it would be necessary to fire 9 rounds. That's what makes me wonder. Let's see. I'm going to actually check. That's what makes me wonder if Illinois has a magazine capacity limit. I'm just going to Google it quickly. It looks like they enacted a 10-round magazine limit this year in early 2023. That's what the NRA is telling me when I Google it. So if this guy has a 10-round mag in his Glock and it's topped off and he has 1 in the chamber, that's 11 rounds. So he may have just panicked and done a mag dump. But a panicked use of force in self-defense, that's not reasonable, folks. By definition, that's panicked. So I think this guy's in a very, very, very difficult legal position, and it looks like he ought to be. Is there other stuff that could have been done here? First of all, just the fact that I guess it's his friend, the other fellow who's wrestling with Perkins. Why is this happening at all? I mean, especially early in the video, they're separated. The friend walks up to Perkins. Perkins doesn't walk up to the friend. This is ego getting engaged, folks. And ego results in people getting killed all the time for no good reason, like this appears to be. So please, if you find yourself in circumstances where things are beginning to escalate, you have to be making ego-less decisions in self-defense. And I'd like to think that I don't have any friends who would be this stupid that I would need to think about, do I have to risk going to prison for the rest of my life to defend that stupid friend? If you have friends this stupid, you might want to reconsider that friendship and what you're prepared to sacrifice for that person, because it looks like Freund is going to sacrifice the rest of his life in prison over this nonsense. Now, he is telling him separate, separate, separate. That's good, but he blows all that up by going to the gun under circumstances where it's just very difficult to understand. I just don't see the justification at all. Now, again, facts could change, right? If Perkins was presenting a knife, so under conditions of mutual combat, what I described really applies to, I mean, there is no lawful form of deadly force mutual combat, right? That would be dueling, and we don't allow dueling in the United States. So when we use the term mutual combat in a legal context, we're really talking about non-deadly mutual combat, fist fights, wrestling, this kind of thing. And if two guys are engaged in mutual combat, non-deadly mutual combat, arguably they're mutual aggressors. They've both lost the element of innocence. Neither one of them can claim self-defense. But that can change if one of them decides to escalate that non-deadly mutual combat to a deadly force level. So they're doing the wrestling here. Let's imagine that Perkins presents a knife. He's now unlawfully escalated a non-deadly force fight to deadly force. And to look at it from the other gentleman's perspective, the legal argument would be, well, he's lost innocence for the non-deadly force mutual combat because in effect, by engaging in mutual combat, he's consented to the use of force upon him, right? If two guys get into a mutual combat fist fight, they're each effectively consenting to getting punched by that other guy so that they can justify their own, not legally justify, but so they can throw punches back. But two guys engaged in non-deadly force mutual combat, they're not consenting to deadly force. They're not consenting to getting killed. They consented to a fist fight, which typically doesn't kill. So if Perkins had gone to a knife or a gun or some other deadly weapon here, arguably the other fellow wrestling, now there's a new fight. So the non-deadly force fight was mutual combat. He doesn't have a privilege of self-defense there. But then Perkins would have started, in effect, a second fight, a deadly force fight, in which Perkins was the unlawful deadly force aggressor. And for the purposes of that second fight, the other fellow would have a legal justification of self-defense to defend himself from that unlawful deadly force imminent threat to which he hadn't consented. And perhaps that could give rise to the fellow here with the gun to use deadly force in defense of the other fellow, because the other fellow would have regained a privilege of self-defense. By extension, that could be applied to defense of others in this scenario as well. Now, this is all, there's no evidence that I've seen that Perkins did anything of the sort. I'm just exploring, small changes in facts can lead to large changes in legal outcomes in use of force cases. That's the kind of thing I would need to see evidence of Perkins escalating to a deadly force level, in order to have any hope that Freund's display warning shots with a gun would be lawful. And all that would have to happen, that kind of escalation by Perkins would have to happen before the gun came out. Because if the gun comes out first, then arguably that's the escalation. As we already talked about, then arguably Perkins would have a privilege to resort to deadly force to defend himself against Freund's unlawfully displayed gun.